afternoon, everyone, and thank you for joining us today. My name is Shan Greer, and I am a co-founder of CADRIn together with my colleague Maria Ahmed. CADRIn is short for Caribbean ADR Initiative. It is a nonprofit organization whose objective is to inspire Caribbean nationals to use ADR for viable and efficient outcomes where disputes occur. Today's webinar is the last in our series, and we will be discussing document management and arbitration. In the context of arbitration proceedings, document management is associated with the process of collecting and presenting factual evidence and is largely a party-driven process, with the arbitral tribunal usually having limited involvement. During this session, we will be asking our experts to share their respective experiences and perspectives on the topic. Document management, though an important part of the arbitral process, is not the sexiest or most interesting of topics. To make it a little more relatable, we're going to be addressing the issues using a case scenario. Our panelists will then consider the issues from the perspective of various players in the arbitration market, which we hope will not only facilitate discussion, but provide a broader perspective on the various issues. So without further ado, I'd like to introduce our panelists. We have CADRIn Simpson. She has served as an arbitrator in multi-party international disputes and has conducted virtual hearings. Over the past 10 years, CADRIn has been involved in over 30 international commercial and investment arbitrations. She frequently writes and lectures on the topic related to investor-state arbitration. CADRIn will be speaking from the perspective of arbitrator in the webinar. We next have Francois LaSalle. Francois is the Chief Executive Officer of the BVI International Arbitration Center, responsible for the overall growth management and operations of the institution. The BVI Arbitration Center is an institution established to meet the demands of the international business community for a neutral, impartial, efficient, and reliable dispute resolution in the Caribbean and the Americas. He will be speaking from the perspective of the arbitral institution. Next, we have Hafez. He is the president of and a co-founder of Delos Dispute Resolution. He currently serves as an independent arbitrator, but has previously acted as counsel in disputes across a wide range of sectors and relationships. He will speak from the perspective of counsel. And last, we have Camille. She is an independent tribunal secretary and a New York qualified attorney who focuses her practice on international commercial and investor-state arbitration. She worked as a legal fellow at New York University's Office of the General Counsel, and she will be speaking from the perspective of the arbitral secretary. So we just want to go through the facts of the case scenario, which we're going to be using for today's webinar. So we have a French company who has leased an oil drilling rig to a Trinidadian oil company for 550,000 US per week. After 2 months of operation, the Trinidadian company stopped using the rig. It claims the rig was defective and not fit for purpose. The Trinidadian company is claiming a refund of 4.4 million, being the amount paid to the French company and loss of profits. The French company denies the claim. Despite their best efforts, a settlement is not possible. The contract includes the following arbitration clause. And given that we have invited Francois to join us, we have used the BVI Arbitration Center model arbitration clause. And so for the purposes, we'll be using the BVI arbitration rules. Okay, so the first topic we're going to be looking at is document submission by the parties. So the negotiations have failed. The Trinidadian company wishes to file a notice of arbitration pursuant to Article 3 of the BVI arbitration rules. Counsel for the Trinidadian company, together with its in-house counsel, are discussing the logistics of submitting its notice, including the extent to which the documents it intends to rely upon should be submitted into evidence at this early stage. Let's move over to Francois. Francois, do the BVI arbitration rules make provision for the submission of documents at the beginning of the process?
Thank you, Sean. Yes. So the short answer is yes. And the notice of arbitration is a specific document, so we don't have a template for it, and it needs to contain certain things, like the arbitration agreement, the contract, or the legal instruments out of which the dispute arises. But Article 20.4 of the rules states that the claimant may elect to treat its notice of arbitration, referred to in this original Article 3, as a statement of claim, providing that the notice of arbitration also incorporates everything. So you can add reliance documents in your notice of arbitration. As an institution, you see, and the others will hopefully agree, you see different cases. Now, the rules of the BVI are very flexible, so they traditionally allow parties and tribunals to flex the process to meet their needs and requirements. And this is what makes them modern, and many other institutions have similar rules based on the ancestral model law. What is important to realize is whether parties actually know what they're doing. Sometimes it's really good for parties to provide those documents very early on, when they experience an international arbitration, when they've gone through that process a number of times. But sometimes it's better to wait for the tribunal to provide some directions about document production, so that you end up with a complete mess. So the short answer was yes, the rules are flexible enough to empower parties to do this. The real question is, should they do that every single time? Probably not. I mean, this is a case-by-case type of decision.
And thanks, Francois. And that gives us a very convenient transition to Hafez. In terms of disclosing documents at the early part of the process, is there any benefit to filing a shorter notice of arbitration with documents submitted into evidence at later phases of the process? Or in this instance, what factors would you think we would take into account to determine whether or not to produce documents at this to disclose documents or submit documents at this early stage of the process?
Well, thanks, Shan, and thanks to you and Baria for the invitation. If you'll forgive me, I'll, given that I'm wearing my counsel hat here, I'll start with the typical counsel answer, which is it depends. And then when you go further, it really is a question of, so on the one hand, what Francois mentioned about experience, but I think also about strategy and about how much you know of your case. And some of the things you may want to take into account are the following. If you're in a straightforward payment dispute, for example, and you know that there really isn't a case to be met by opposing counsel, then probably what you want is to put your case up front in full, so that the arbitrator or the tribunal knows what they're faced with, and you save time along the process. Conversely, if you're in a situation where you've had to file your notice of arbitration urgently because you need certain relief, but you haven't had a chance to do a full due diligence on the case, you'll be very hesitant to put in a raft of documents that you haven't analyzed fully, haven't considered their implications fully, especially knowing that under the BVI rules, there's going to be a statement of claim later on, and you'll have a chance to develop your case. And I'll let Francois comment on how long one should expect between the notice of arbitration and the statement of claim, but that time is going to be precious.
Thanks, Hafez. That certainly gives us some food for thought in terms of factors that counsel can take into account when trying to decide the best time to disclose their documents or submit their documents into evidence. In terms of ensuring that those documents are helpful, Camille, what are some of the practical steps that parties can take to ensure that the documents that they've they submit into evidence help the tribunal to understand their case?
Great. Thanks, Sean, for the invitation to you and Varia. So above all, out of really any method used, organization is really key, especially for document-heavy cases. So in my experience, the most common method I've seen for getting documents to tribunal is to put everything on a flash drive. And in my perspective, this is really a best practice because it allows the tribunal to easily travel with documents, or back in the old times before COVID. And they can also easily locate the documents during virtual hearings. And in addition to using flash drives in that regard, one thing I found particularly helpful is to implement hyperlinks within all submissions, particularly in any memorials, because this ensures that when a tribunal is accessing relevant documents and looking for supporting evidence, they can immediately find it. They just need to click a link and it immediately appears. It's not a practice everyone uses, but it's one that has been tremendously helpful for someone, particularly in my role. And it's also important if they're quoted portions of the documents within the text of a memorial. So if the tribunal wants to make sure that a quote hasn't been taken out of context, that it's actually supporting the argument made, it also ensures that they can find the document. And if it's overly burdensome to hyperlink memorials, hyperlinked indexes are also very helpful. So with a description of each document, with the organization system used. And these turned super helpful for me towards the end of arbitrations when I get instructions from a tribunal that says, oh, I remember the claimants referenced X in a document, but I can't seem to find it. I can't seem to locate it. Having the ability to search through indexes when it doesn't seem to be in the memorial or doesn't seem to be fully elaborated in the memorial has been really helpful. And one final aspect to it that I really urge the parties to consider too is the role of the tribunal secretary isn't always established at the beginning. So I found in many of the arbitrations I've worked on that I got brought in at a later stage. So I got brought in right before the hearing started or even after the hearing started when the tribunal realized it needed more support. So in those cases, the tribunal secretary has an immense amount of documents and memorials to catch up on. So any form of organization is really essential to helping someone like me in my role.
Thanks for that, Camille. And now I'm going to move to CADRin, and from the arbitrator's perspective, because we heard Hafez say some of the things that from a counsel you'd want to take into account. In terms of the arbitral tribunal's perspective, do they have a preference as to the time in the proceedings when documents should be exchanged by the parties?
I think that there's a preference, which first you're going back to what Francois said, it has to happen at a time that's consistent with the rules. And and the BVI rules are very flexible on that at any time, really as the tribunal shall determine. So helpful and supportive, but doesn't quite, you don't get the answer directly from the rules. So the next step for me is it's at a time that enables the parties to prove or disprove or discontinue their cases at the earliest possible moment that also ensures that each party has a full and fair opportunity to present its case, with the hope that the procedure will only happen one time. So you're going to what Hafez said about early production along with the notice and the brief response. Of course, at a minimum, I think what an arbitrator needs to see there is the information that will help the arbitrator or the tribunal establish whether there are any conflicts of interest. That's a really key point with those very first evidentiary submissions. But after that, of course, you are going to have a statement of claim and a statement of defense. And in the statement of claim, the claimant is going to hopefully submit all of the documents that it has and will rely on to prove its case, but will also make indications about what additional evidence it might be seeking, or maybe not. But the respondent will respond. And often in that exchange itself, the parties together have already independently produced everything that they need to. But if not, after that, and of course this would be pursuant to a calendar set up before this stuff even happens anyway, but after that, it's helpful for the parties to get together and decide first together if they can agree on who is going to give which piece of evidence to whom. It's wonderful if the parties can agree on that themselves, and if not, then to submit a joint request to the tribunal with their arguments in favor of that evidence and arguments against, often in the form of a Stern schedule or a Redfern schedule.
Thanks, Catherine. We're now going to move to the topic of disclosure requests. So we're back to our scenario. The tribunal has now been constituted. The chair emails the parties with the view to scheduling the first case management conference. In her email, the chair sends a draft agenda to the parties and invites them to add additional items for consideration. She also suggests the use of the IBA guidelines on taking evidence. Counsel for the French company, together with in-house counsel, are considering what additional items they need to have included in the agenda. In-house counsel has advised that there are several items of correspondence and technical documents in the Trinidadian company's possession relating to the operation of the oil rig by the Trinidadian company, which may be helpful to their case. When the parties negotiated before the commencement of the arbitration, in-house counsel asked the Trinidadian company for these documents. The Trinidadian company refused because the documents were irrelevant and/or confidential. The French company believes these documents harm the Trinidadian company's case, and this is the reason they are refusing. In its cost-benefit analysis, the French company estimates the cost of securing the production of these documents at approximately $15,000, with a 10% chance it will yield valuable results. Hafez, is the benefit of document production worth the cost, and what factors do you take into account when you're trying to consider whether or not to make production requests?
That's a vexed question you're asking. So maybe we'll start with some maths. If I remember correctly, the amount in dispute is 4.5 million roughly. Now, when we're saying that there's a 10% chance of a valuable result, you could presumably quantify that at about $450,000. If you compare that with 15,000, clearly it's worth it. But that's not usually the way the thought process works. I think there are two things you want to consider when you're thinking about document production. One is, do you need documents from the other side? And when you're thinking about need, there are two ways of thinking about it. There is, I actually need the documents to build my case, or I want to put the other side in an embarrassing position from which I can draw adverse inferences. But then the other aspect of this question is, clearly, if you're going to ask for documents, you're going to be asked documents in return. And you've got certain parameters to how the exercise takes place. Even by saying Redfern or Stern schedules, there's going to be a question about how large is the fishing net, or what approach is taken. I imagine Camille and Catherine will comment in more detail about that. And then there's a final consideration, which I will probably let them comment about as well, which is, what are you entitled to seek? So there are the usual parameters of privilege and so on, but there can also be a debate about, are you entitled to ask for documents that fundamentally go to the other side's burden of proof?
Thanks. Are you done, Hafez? Yeah.
Yeah.
Okay.
Sorry.
Yeah. Thanks. Yeah. So I was sorry about that. Yeah. Thank you for that. And I know that document management in arbitration tends to be a party-driven process. But Francois, I wanted to ask you: is there a role for the institution in reducing the cost of the exchange of documents and the use of the rules, and how do the rules assist the parties to make this an as cost-effective process as possible?
So when it comes to the rules, they place the responsibility on the arbitrator. The arbitrators have to. Sorry, I'm trying to find the article. The arbitral tribunal, in exercising its discretion, shall conduct the proceedings so as to avoid unnecessary delay and expenses, and to provide a fair and efficient process. So the duties on the tribunal to work with the parties so as to minimize cost and to ensure that the proceedings are fair. The institution, and I'll use a fair saying on this one, it depends. We can do as little and as much as parties and the tribunal requires. Now, from our perspective, every time documents are submitted and so on, we index them, we hyperlink them, we host them in a very secure document management platform, and the indexing is a document that allows us to send it to people and they can access the secured document. So you only have one document that all the parties and the tribunal can access directly on our systems. So we do all of this. They may decide not to use it, and we cannot force them to use it. So our rules do not entitle us to forcefully push parties or the tribunal, for that matter, into a very specific protocol that would be highly efficient. What we do is, as part of the conversations we do have with the tribunal and the parties, we tell them that this is available. We tell them that we've got tools that are available to them as part of the package that would facilitate document production and exchange and so on and so forth. We also, I mean, we've mentioned the Redfern schedule, and maybe the audience doesn't know what this is. I mean, it's a very simple piece of paper that has, what are the documents the claimant, for example, is requesting, why they're requesting them, the respondent's objection, and basically the tribunal decision as to whether these documents are admissible or not. And it helps with document production. If you're not using that, then you kind of have a problem. Most parties will use something like that, but if they don't know what they're doing, we can provide those templates. Similarly, we can provide templates for document agreements to by default validate the authenticity of the documents that will be provided, or force documents that are not in English to be translated in English by default, and things like that. So we can help the parties streamline document production, either by supporting with our technology or just our skill set. But this is a service that we can only offer, not push onto parties and the tribunal.
Thanks, Francois. Now, if you recall, in this case scenario, when the chair had sent the agenda, she had suggested the use of the IBA guidelines. In this case scenario, the French company actually prefers the Prague guidelines, which are more consistent with the civil law approach. Camille, what are the, broadly speaking, differences between the IBA guidelines and the Prague rules? And how do you think it would benefit the parties in terms of deciding which is more appropriate for their case?
Sure. So at its most simplistic, the difference between the IBA guidelines and the Prague rules can be viewed as you mentioned, the distinctions between common law and civil law procedures, or an adversarial system versus more of an inquisitorial system. So under the IBA guidelines, requests for documents production can be a little bit more broad, that the rules allow, under Article 3.3, they allow parties to provide sufficient detail to narrow down a category of document, which is a lot more expansive than what you necessarily expect in a civil law system. Additionally, the IBA guidelines provide procedures for a tribunal to weigh on objections. So if a party objects to document requests made by the opposing party, it must state its objections in writing to the tribunal. And within that determination, the tribunal can ask for the requested documents to be produced. And if it's an extraordinary circumstance, the tribunal can decide it shouldn't view the document and can appoint an independent expert to rule on admissibility. As you might imagine, this can drive up costs and slow down efficiency of a case pretty quickly. At the same time, the IBA guidelines also provide for 7 grounds for which the tribunal can exclude evidence. So in this case, one of the reasons given is that it's an unreasonable burden to produce the requested evidence. So the tribunal might weigh the cost, if it were significantly higher than the $15,000, for example, with the chance of success, and decide that the cost is too high to justify the production of the documents. Similarly, the Trinidadian company had also raised issues of lack of relevance to the case, as well as confidentiality issues, which also are grounds that a tribunal can exclude evidence based on the IBA guidelines. So ultimately, what can be taken from this is that with the IBA guidelines, they allow for less expansive discovery than what you would necessarily expect in a US court system or other common law jurisdictions, but it's significantly more expansive than the civil law approach, which is what you find under the Prague Rules. So under the Prague Rules, document requests must be to specific documents. There aren't necessarily guidelines for rejecting document submissions, but within the rules, the tribunal's given a more proactive role in document discovery and fact-finding in general. So the tribunal can control the procedure for document production, but can also request documents itself. So in terms of a balancing act, some arguments can be made that the Prague Rules allow for more cost effectiveness and more efficiency, but really it depends a lot on the attitude of the tribunal in this regard, because you can have a common law tribunal under the IBA guidelines who says no to absolutely everything, and you can have a civil law based tribunal applying the Prague Rules who decides it needs to know significantly more about document production. So ultimately, I'd say when deciding between the two, it ultimately comes down to who's on the tribunal and their attitudes towards each set of rules, and also the comfort of the parties as well.
Thanks, Camille. And Catherine, from an arbitrator's perspective, in your experience, to what extent is document production genuinely useful and necessary to the tribunal? You need to unmute, Catherine.
That's a great idea. I'll do that next time. It's genuinely useful to the parties because often the documents and the materials that you need to prove your case happen to be in the other side's filing cabinet. So in that sense, there are documents that you, as a claimant or as a respondent, would not be able to access on your own without some kind of procedure for it. That being said, I think you're asking the importance of the entire procedure for the tribunal, where the parties are saying, I need this group of evidence because I need this to prove my case. Counter argument, no, it's not necessary. Counter argument, yes, it is. No, it's not. Tribunal decision, just to put it shortly. And that entire argument is, I mean, you can see how relevant it is by reference to perhaps simply the fact that tribunals do not cite to those arguments in their awards. So as far as shaping a tribunal's view of the case, whether a party argues very strongly that one kind of document is needed while another is not, I don't think that that really has a measurable effect on the award. But what I think tribunals and arbitrators are really looking at is how relevant and material are these requests to the establishment of the case, and not just how burdensome it is, but also, is this necessary? Can the party prove this point with these other 4 documents that it's already given us? Is it duplicative? Nobody needs 10 or 20 files explaining the same thing. And so I think often tribunals will work hard to reject those kinds of claims, especially for because of the different cost implications of them for the parties.
Thanks, Catherine. Now, I know that the exchange and document requests is usually a fairly contentious part of the process in some instances, and everybody has their war stories from that case from hell. And we wanted to, just to encourage some discussion, ask if anybody, first of all, had any questions that they wanted to ask on the points that we've raised so far, and also if anybody wants to share their own experiences on issues with document production. So feel free to either leave your question in chat, or if you raise your hand, then we can choose persons who want to share. Anytime, can I put the panelists on the spot? Do any of you want to share some of your own stories?
Well, I'm guessing Catherine's been on the opposite side of this, and so has Camille, which is when you've got to put together document requests that run into the hundreds of pages. Those are not the ones I favor, but they do happen.
Yeah.
Yes, there. Am I off mute?
Yes.
Okay. There was a publicly reported such event where an arbitrator received one of those 200 or 500 page document requests and emailed the tribunal secretary a very general message saying, "What do you think?" Now, as an arbitrator and as a former tribunal secretary, I know exactly what that arbitrator meant by "what do you think?" He didn't mean how would you determine each and every one of these document requests. He meant how many document requests do I have to determine out of this 500-page document? Because you see, these 200, 500-page long requests come with 270 zillion requests in them, and you have to go through and see if all of them are still live, because the parties showing in the spirit of their cooperation will show every request that they've made to one another and whether they have been able to come to agreement or whether it's been withdrawn, so it still stays in the document. So what I think that arbitrator was asking is, do I have 5 requests to determine, or do I actually have 70 or 200? How much time do I need to set aside to address this very large requests document?
And Francois, again, I maybe slightly put you on the spot, but I know that certainly with the issues that have arisen due to COVID, everyone is relying more on technology to administer arbitrations. So do you think that in recent times, persons are relying more heavily on technology for the management of documents?
Well, they have to. I mean, you don't ship big core bundles of documents, on the other side of the world. So everything has gone digital now. I mean, you used to get a flash drive here and there. Now it's all hosted. Well, from what I've seen, and I think I think that's a positive thing. I think COVID. If there's one silver lining for arbitration, I think COVID will have created some long-term efficiencies, and will have forced people that would otherwise have been quite reticent to embrace certain aspects of or certain tools, technology tools. I've just had to accept them and to start using them. And I think going forward, we will see more technology embedded in the process. Even though we may have in-person hearings, I think we'll see less and less big bundles of documents. We'll see more electronic presentation of evidence. We'll see more of this, and I think it is a great thing, not only for the trees, but for the ease of use, the security that you can build around it, and the portability of the documents themselves. So yes, that COVID accelerated the change. I think the change started before, but I think it has indeed accelerated over the last 10 to 12 months. And similarly, and let's forget document production for a minute. Even video conferencing has evolved quite drastically. I mean, Zoom, used to get an update every 9 months or whatever. They're updating that platform significantly with security features every 2 or 3 weeks now. And I think those platforms have now become more business focused, because they've been critical to enable people to continue, for business continuity over the last 12 months. And I think this is going to stay, like this progress in the technology all around to operate virtually is here to stay, and people will continue to use that.
Yeah, and Francois, you made a good point about the updates to make sure that the technology that we're using is secure. And certainly security of tech-human documents is an issue that we have to give consideration to. Camille, when you spoke earlier, you talked about the international standard in terms of providing thumb drives with documents and other ways that documents are submitted to the tribunal and the parties. Would you be able to just give us an idea of some of the security measures that are frequently used to ensure that those documents maintain their privacy?
Sure, of course. And I mean, a big portion of what Francois was saying, with the move to a more virtual setting, cybersecurity measures are becoming increasingly more important. So within the thumb drives, what I've observed at least is several law firms seem to have proprietary software to password protect it, to ensure that third parties couldn't necessarily access the confidential documents required. It did cause some issues in one of the arbitrations I worked on, since the proprietary software only worked on PCs and not Macs. So in terms of best practices, make sure it works for everyone, since that caused significant issues. But I would also refer people to look at the ICA, New York City Bar, CPR cybersecurity protocols that came out at the end of 2019. They really provide a good way to ensure best practices in terms of password protecting, in terms of, well, I guess a little less now, but what to do when traveling. They talked about the need to put on privacy screens, for example, which is something, even at conferences, I'd seen arbitrators open documents and everyone behind could see exactly what it was. So privacy screens are also really necessary. But I would definitely recommend checking out that report. to just ensure that the best practices are being used and staying safe.
Yeah. And of course, the #1 rule, don't send your password with the thumb drive.
Exactly.
Yes.
All right, so we move on to the next phase of our case scenario. The Trinidadian company wishes to rely on documents produced by its resident engineer who managed the operation of the leased oil rigs. Unfortunately, the documents were placed in storage and cannot be accessed due to the restrictions relating to the pandemic. The Trinidadian company does not know when the current restrictions will be lifted, but by all indications, they are likely to last for another 6 to 8 months. In this instance, what steps, if any, can counsel for the Trinidadian company take to address this issue at the case management conference? And I think we'll start with CADRIn if you wanted to address this issue. Oh, you need to unmute, CADRIn, sorry.
Now I'm going to have the computer problem of the day. So the party wants to rely on a document that the party has in its own possession, but the party itself cannot access it. What is that party to do? At the case management conference, of course, the parties could create some sort of schedule, proposals for when things are going to be due. But of course, you also don't want a case to be delayed and delayed and delayed, especially for a piece of evidence that a party itself owns and that the party itself needs to rely on. So those parties might want to consider how else they could prove what they need to prove, because it's wonderful TV, but there is rarely a smoking gun in a proceeding or in a case. But often the arguments that such a smoking gun would produce are confirmed by lots of other contemporaneous evidence, and especially witness documents and presentations. So at the case management conference, the parties could could also just begin there talking about, are we going to have witnesses, and how are we going to use them? And now I will pass back to Shan.
Thanks, CADRIn. And Hafez, CADRIn made reference to this, the age-old smoking gun that everyone is trying to secure. In terms of, from a counsel perspective, how do they tend to try to deal with these issues, or what experiences given issues where documents cannot be accessed temporarily?
There are multiple thoughts I'd like to be able to share. One is on the smoking gun point. You can obviously not say 100% on anything, but by and large, no, there are no smoking guns. I've come across situations and cases where document production has been helpful. If nothing else, then to put the other side on the spot. But that's procedural tactics arising from document production rather than document production itself. Mm-hmm. Then the next consideration is, going back to what CADRIn was saying, how else can you make your point? And indeed, in this case, a Trinidadian company might want to put forward a witness statement by the engineer. Conversely, if I were acting for the French company, I'd be up in arms. I'd be saying, wait a minute, you're claimant, you're saying that you want to delay this case and you want to rely on documents that you can't access. You don't have a case, you're just buying time to put pressure on me and build up my costs. And I'd be saying, no, wait, we're getting on with this. And if you can't make your case, then withdraw it. So it depends, is never a satisfactory answer, but it really comes down to what hat you're wearing, what are you trying to achieve, and what do you have at your disposal to achieve it?
And CADRin, from the perspective of the possibility of challenging awards and parties arguing that they haven't had an opportunity to produce their case, do you tend that these issues tend to come up when you're dealing with situations where parties need additional time to secure documents?
Well, actually, I think that is one of, mentally, that is always at the forefront, because due process is among the only ways to undo an arbitral award. So the question of, is my decision here going to hurt the outcome over here is an essential consideration. So, and it really depends how many different kinds of opportunities can you give a party to prove its case and to meet its burden of proof. But yes, that key due process question, has each party been given a full or fair opportunity to present its case, is at the forefront.
Can I jump in here, please, Sean?
Sure.
So if I remember correctly, your scenario at the very start, it said the seat of the arbitration is Tortola in the BVI. And the BVI were covered as a jurisdiction in the Delos Guide to Arbitration Places, but it was only assessed in 2018. We have a 10-point criteria assessment. And at the time, it came out with green traffic lights on all criteria. Now, I'll let Francois comment about whether that's still the case today. I'd imagine it is. But really what I was getting at is, and this is a question for whoever on the panel wants to take it, given the attitude of BVI courts to arbitral awards or to arbitrations, to awards in cases seated in the BVI, to what extent is it really a concern if an arbitrator exercises a firm hand?
And Francois, did you want to share, Tim, from a BVI perspective, what attitudes are generally taken?
So the commercial court has a long history of supporting arbitration and staying court proceedings in favor of arbitrations, even before the most recent enactment of the Arbitration Act, and even before the Arbitration Center was created by said Arbitration Act. So I would trust that an arbitrator could be as forceful as possible, as reasonable, I would say, here in the BVI. But this is not a fight. I mean, at the end of the day, it is an arbitration. It's about getting to the right results and producing an award that hopefully will not get challenged. And so, in this scenario, it would be a tricky case management conference. I think there would be a lot of back and forth. What CADRin said, are there any other ways that you can actually make that point? I would argue, these guys probably should have waited a bit more before sending the notice of arbitration, so as to secure those documents. And if they do know what's in the documents, that they can use a witness statement to make their case. So there is rarely no option for the tribunal to make the right choice. What we haven't discussed is that French and Canadian companies may have other contracts for other rigs. They may not absolutely hate each other. And the French company might be perfectly willing to stay that arbitration for 8 or 9 months until they can actually retrieve those documents. So there are loads of different scenarios that could be at play. For the parties and the arbitrator to make the right call on that specific set of documents at this point in time.
Yeah. And I think this also highlights the importance of choosing a seat with an updated Arbitration Act, and ensuring that you do have a jurisdiction where the courts have a supportive attitude towards arbitration. Because of course, this is going to be one of those issues where you're relying on the discretion of the courts, and it may well be, if you're in a jurisdiction that isn't particularly friendly to arbitration, that it may go in a way that the parties that they don't intend. Camille, did you want to share some of your experiences in relation to this area?
Well, for me, it hasn't come up yet, though I know with a lot of the lockdowns in South America that this issue has arisen for some colleagues. But most of the points raised by Francois were actually issues that I'd been thinking about in terms of this hypothetical, just in regards to the feasibility of getting the documents despite lockdown, with other support. So really, Francois covered it very well.
Okay, great, thank you. All right, so we moved to our next topic, which is documents at the hearing. The parties complied with the directions issued by the tribunal, and the matter progresses to a 2-week hearing. During cross-examination, one of the witnesses by counsel for the Trinidadian company, during cross-examination of one of the witnesses by counsel for the Trinidadian company, he relies on a document which was included in the hearing bundle, but not previously disclosed to the other side or the tribunal. Francois, do the BVI arbitration rules address this matter, and what provision has been made for issues relating to disclosure? Oh, we can't hear you, Francois.
I didn't want CADRIn to feel alone in.
Fair enough. Fair enough.
So the BVI rules are supportive of this. Article 27.3 says at any time during the arbitral proceedings, the arbitral tribunal may require the parties to produce documents, exhibits, and other evidence within such a period of time as the arbitral tribunal shall determine. It's vague enough to be highly flexible, and it's putting the decision on the tribunal to make those decisions on a case-by-case basis. So the rules are not prescriptive, if you wish. And this should happen. Sorry, I was finished and then decided I wasn't. And this and this is still within the constraints of Article 17, which says that the tribunal, within its discretion, shall conduct the proceedings so as to avoid unnecessary delay and expense, and to provide a fair and efficient process for resolving the disputes. And it's also making sure that the parties are treated with equality, and that they are presented at every single step of the proceedings presented with a reasonable opportunity to present their case. So there are constraints as to what the tribunal can do, but some emphasis on efficiency for the arbitral proceedings.
Thanks, Francois. And Hafez, from counsel perspective, what course of action can or should the French company take in dealing with this matter?
So here I'm wearing my respondent hat. And I think that it comes down to what strategy you're trying to adopt. At one level, you could say, oh, it's a big issue. They're relying on a document that's not on the record and so on. At a very big picture level, and Catherine will contradict me if she thinks differently, but the very big picture level is not going to be an issue. It's going to be resolved. So then, as counsel, the question you want to ask yourself, and that really is a determination on the spot, is, do you know the document? Do you know what it stands for? Do you think your witness can handle it? If so, then try and score a point with that. If not, or you're not sure, ask for timeout. If it's a problematic document, then maybe make it a procedural incident. You might want to have it set aside. You might want to just say, you know what, you're going to object. You're going to anyway sort of gain time there. And at that point, you might say, let's put that document aside for discussion with the tribunal. We can maybe come back to it later. I doubt you'll get much more mileage out of that, except if it were a document that for which you requested production, you had an objection, production wasn't ordered, and suddenly it appears at this stage. At that point, you might get a lot more mileage out of it, but it's going to be a snap decision, and in all likelihood, your best course of action is going to be object, time out, the document will be put aside, and you'll come back to it later.
Thanks, Hafez. And Camille, are there any soft laws which can provide some guidance to counsel on how to deal with these issues?
Well, turning back to the IBA rules and the Prague rules, within the IBA, Article 311 echoes a lot of the language that Francois mentioned was in the BVI rules. So it allows, it was Article 310. So that the tribunal at any time before an arbitration concluded can request any party produce documents. And so under the IBA rules, there's at least a little more flexibility in terms of the documents coming in at any time, though obviously there is a preference for the documents to come in towards the beginning of the arbitration. Within the Prague rules, there's significantly less flexibility, as would most likely be expected. That it even goes as far as in Article 4.4, saying that a party can only request documents be produced at a later stage in exceptional circumstances. And within that, they have to show that the request couldn't have been made at the case management conference. And within the rules themselves, within Article 4.1, there's already an emphasis on submitting documentary evidence as early as possible. So there's a little bit of guidance in both, but nothing super specific.
Thanks, Camille. And
if I may...
Oh, sure. Go ahead, Francois.
Just very quickly rebounding on that, I just wanted to highlight that with the rise of virtual arbitration, if you go through the various protocols of practice notes that have been published, not only by us, but by other people, the rules really are pushing parties and tribunals to only accept and admit documents that have been shared before the hearing. Like, you cannot come up with a new e-document during the hearing in a virtual arbitration. It's just not going to cut it. So, there is also, a change there in terms of what people will perceive as acceptable or not, between in-person hearings and virtual hearings.
Thanks. And Catherine, what sort of approach or attitude do tribunals take to this sort of action that the Trinidadian company engaged in here?
Well, going back a step, often it can be a total surprise to everyone in the room. So there's a bit of case preparation there's a bit of case preparation groundwork that you have to have laid to even be able to see the problem. And I'm sure that Camille does this a lot. For me personally, I make a tribunal USB, and it's hyperlinked, and it has a ridiculously long table of contents of everything that's been submitted, exhibit number, name of document, hyperlinked to that document. And I use it and I update it throughout the case and often before a hearing, the parties will jointly submit a hearing USB that already has a nice table of contents. It's their entire bundle. It's wonderful. But it might not contain my correspondence with the co-arbitrators. So I tend to use my USB and rely on theirs. And what happens sometimes is a witness is being examined, and they'll say, you turn to exhibit R28, and they'll start reading through parts of it. objection, R28 only has 2 pages and the witness is reading from page 4. So you can discover in the middle of a cross-examination that that perhaps the documents between one and the other are not actually consistent, and that the parties have just now learned of it. So, and it's a problem for counsel, as Hafiz was referring to, because in that situation, the counsel hasn't had the opportunity to argue whether the document would have been admissible from the get-go anyway. So the tribunal has a few options before it. Of course, have a pause, let the parties determine how they think that this should go forward. But if they can't come to an agreement, well, the tribunal can cancel the hearing, which is probably very expensive and will be very difficult to reestablish a hearing, or see if the parties might agree to continue the hearing and continue with the cross-examination on all of the documents that are on the hearing USB, doing that, however, without prejudice to any argument that the entire examination may need to be thrown at the end, or that the parties may need a further opportunity to submit responsive evidence or witness statements on the specific document. So it happens, and you can work with it, fortunately.
And have you, and I guess we can put this question out to Camille as well, and Catherine, do you find that this issue arises very often? And when it does happen, have you had any experiences where hearings have had to be canceled because of these sorts of issues arising? Or, yeah.
Oh, I've never seen a hearing canceled over it, and I've only seen it happen once, but it happens. So.
And yeah, I've never seen a hearing canceled over it. I think the scenario that Catherine brought up of an exhibit having 2 pages and they're reading from page 4, that has come up occasionally, but nothing serious enough to warrant canceling a hearing.
Okay. All right, thanks for that. We now, having ended this scenario, that's the end of the issues that we want to deal with. We just wanted to open up to any questions, and then we'll ask each of the presenters to give any final thoughts that they want to, having dealt with all of the issues. So we want to open the floor. If anyone has any questions, you can type them in the chat, or you can just click on the raise your hand, and then Barrio will invite you to ask your question. Seems our presenters did an exceptional job, and there are no questions whatsoever.
You're saying that like you sound surprised.
No, these are the trials and tribulations of choosing a very good panel. You have no questions. Okay, so Camille, can I invite you to share any final thoughts on the issue of document management?
Sure. So thank you again to Sean and Baria for the invitation to speak today. I think this was an interesting event and very different from other webinars I'd seen too. Having the case scenario was really helpful. For me, I just want to reemphasize organization and the need for it in terms of producing documents to the tribunal. It really makes tribunal secretaries' lives significantly easier.
Thanks, Camille. Catherine?
Well, yes, and this was wonderful, and I'm grateful to be here, and I hope that someday we all get to do a case together and see one another in action, in particular at the BVI IAC.
Thanks, Catherine. Hafez?
Going back to the overall topic of this webinar, with my counsel hat, I would say there's no shortcut to knowing your case. So do your homework, go through your documents. Obviously, within a reasonable measure, you're not going to overturn every single stone if it's a small value case. But conversely, you might go way beyond if it's a very high value case. But really, there's no shortcut to doing your homework. And I'll echo what Camille and CADRIn were saying, that I've enjoyed this, and thank you.
And before I give Francois the last say, we have a question. So I'm just going to put it out to everyone, and then you can make your respective comments. What about arbitrators who are not brought up in the digital age of flash drives and hyperlinks? Are we out to sea? And it's funny because this was an issue that we were discussing just before we started the session. So tribunal, I'm sorry, presenters, what are your views on this? And I think this is one that's a legitimate concern, and I think it means we may well have to do training on how to use the technology.
So I could start a quick answer to this one. I think, you know, if you're already not on the boat, yes, you will have to swim a bit, but there are many people with you that can help you reach the boat. And honestly, there are tools out there that are really intuitive. If it's a BVR IEC arbitration, or, you know, let's face it, an institutional arbitration in one of the other mainstream arbitration centers, case managers will be there to help the arbitrators do the right thing. And doing the right thing is, you know, not difficult. I mean, you know, we're talking hyperlinks and flash drives. I mean, if you have a computer, someone will probably put together those, you know, list of documents, and instead of being printed, you'll be able to click on the link and the original document will come up. So it is absolutely, from a user perspective, the technology that's out there is really intuitive and really easy. It's just, you know, paper you can click on. And providing that the institution helps you as an arbitrator come up with the right directions very early on in the process in terms of taxonomy, document production, you know, document agreements, confidentiality agreements, and so on and so forth. Once all of this is done, it becomes really easy to handle. So I think the technology is really an enabler on this one, and we can always print everything if you end up being at the arbitration center. That's, you know, obviously always an option, but the technology on this one is really an enabler, and not something there to prevent people from you know, carrying on with business.
And I think while, you know, we sometimes joke about it, I think it's a serious issue because you can have this sense of overwhelm. There is so much technology out there. You're trying to figure out which one should I use? Should I go to Zoom? Should I use to go to meetings? And it's difficult. You know, my daughter always says, you know, just go Google, go look in YouTube, mommy. YouTube solves all problems. If you want to know how to link something, go to YouTube. They'll tell you how to do it. And I think if you look at there are other, you know, more established organizations and resources that you can use. And certainly that's one of the reasons why having these sorts of sessions are helpful. I know that some of the references that were referred to, Hafez has usefully copied them into the chat. So please feel free before the end of the session to click on it and download it so you have a copy of it. Did any of the other presenters wanted to address that question?
Yes, I wanted to add something. It is perfectly okay to hire Camille. She did not tell me to say that ahead of time, but you know, making hiring decisions, so outsourcing the parts of the case that you can outsource are really not controversial. I don't think that anybody looks at an arbitrator and says, wow, that is some amazing document organizational skills right there. No, they're looking for somebody who can make the correct jurisdictional decisions and make the correct and enforceable award. And so it's important that I think people understand that it is perfectly okay and valid to hire people who can assist in your arbitrations. I mean, I guess the parallel would be, I'm a homeowner, and but there are a lot of things that come with being a homeowner, and I do not do my own plumbing. I always hire a plumber to do my own plumbing. It doesn't make me any less of a homeowner. But likewise, as an arbitrator, hiring the appropriate staff to make sure that you're able to do your work in the current technology settings that we have is totally acceptable and normal to be encouraged.
Thanks, Catherine. Camille Hafez, did you want to make any comments on that?
Sure. Well, so for me, I was going to add the caveat to my comments that I didn't want to appear too self-interested, but thank you to Catherine for making the plug. But it's a really good argument to hire a tribunal secretary, because often with people, especially from my generation who grew up with technologies and are well-versed, it often becomes our role anyway to help out with those aspects. So, and I know for me, I worked on an ad hoc arbitration recently, and there wasn't the institutional support there for tech. So a lot of the informal tech guru role fell to me as tribunal secretary, and that's a role I think so many of us are willing to take.
Thank you. And we seem to have another question, so I'm going to share it. Does the panel have any suggestions as to how best to handle email documents that sometimes can include all sorts of irrelevant information and may contain pages and pages of unnecessary information? Sorry, Catherine, unmute.
Yes.
Yeah.
Trying to be polite and prevent everyone from suffering the background noise. What I do personally is I save every bit of it. The email, save it by the date. The files that have been submitted, I save it. If I'm the arbitrator and it's been submitted as part of the case, it becomes part of the case file. There's no other magic than that for me, sadly.
Yeah, I think this is one of those, part of the package, necessary evils, that if a party doesn't produce the entire email, then they risk being accused of, manipulating the evidence or not producing the accurate document. But then at the same time, to have to wade through an entire document just to get a few points can also be a bit difficult. And I think it emphasizes the importance of ensuring that documents are paginated, and also, finding ways to make reference to the documents that you want and where it is when you're preparing your case. And I think Catherine made some valid points about hyperlinking, so that when you need to find a document or you need to find a particular section of it, you can find it a lot easier with your own thumb drive. Did anybody else have any comment? Sorry, go ahead, Francois.
This is basically the main issue with document production. I mean, document production is not an issue until you get a large amount of documents that are not concise and presented in a coherent way, right? So this is where it starts to hurt, or when documents are not distributed in time to give the right opportunity for a response. This is where document production, document management becomes an issue in arbitration. And I would like to say that depending on where you are and what rules or the Arbitration Act that governs your arbitration, if it is obvious that a party has tendered documents that were not necessary that they won't rely for their case, that have increased the time and the expenses required to formulate a response, then there is a scenario where cost sanctions by the tribunal may be appropriate And that happens. I would argue that the tribunal should have that conversation with parties very early on, even before the case management conference. If you start messing up with, hundreds and hundreds of, documents that you're not going to rely on, and it's going to add to time and cost of the arbitration, there are going to be sanctions and appropriate sanctions related to that. And that's part of the good case management of a case.
And it's funny that you should mention that, Francois, because the next question actually addresses the issue that you have raised. And it asks, there is a balance to be drawn between the relevance of the documents and the cost of the arbitration. Can cost be used as a control factor to determine relevance? Think too of the arbitrator's time and effectiveness.
Exactly.
So I think you probably addressed that before in your presentation. Did anybody else want to make any comments on the issue of costs as a control factor?
I was looking at the BVI IC rules to see whether there was anything on the conduct of the parties being taken into account in ordering costs, but I can't seem to find anything. But Francois, maybe I'm mistaken.
No, we're not being specific on that, on costs associated to this kind of scenario.
No, not this kind of scenario specifically, but just general language about the tribunal will take into account the behavior of the parties.
No. I go back to article, I think it was 17.1, which is basically asking the tribunal to conduct the proceedings in a way that is efficient and cost effective and so on and so forth. And then they've got tools to enforce that.
One thought I'd put out there, and this is more just for discussion purposes, is when you're thinking of documents, right now we've been looking at it from the point of view of volume and costs and how to manage that. But there can occasionally, infrequently, but there can occasionally arise a situation where party A puts in a document, relies on a point, say on page 2 of a 25-page document. Party B replies on page 2, and then at some point you start looking at the documents and you realize that there's a hugely relevant point at page 10 onwards, and nobody's raised it. And at that point you've got to query as a tribunal, what do you do with that? Now, I'm going a bit beyond the scope of the questions here, but I just wanted to put it out for thought.
Catherine, did you want to? Okay. All right. Thank you very much, Hafez. I think that ends the questions that we've had. Francois, I don't want to leave you out. I know I gave the other panelists an opportunity to give their final thoughts. So I'm going to end by giving you a similar opportunity.
Well, thank you very much for the invitation. I think I'm the only one that hasn't thank you yet, and I do apologize for that, better late than never. And it's been a pleasure with the other participants, and I hope this was helpful to the audience, and I look forward to working with you guys in the future.
All right. Well, I want to take this opportunity to thank everyone for attending. I also want to thank our participant and our panelists. They graciously gave up their time. And of course, what we do would not be possible without persons within the industry supporting us and giving up their time to help us address some of the issues that frequently arise in dispute resolution. Last but by no means least, I want to thank Baria. She is the technical guru who I'm fairly certain if there's a technical question, she probably would be able to answer it, unlike me, who unfortunately have not quite mastered those skills, but still working with YouTube to get there. This, while it seems all seamless, there is a lot of work that goes into making it all happen. And she certainly does that. So thank you very much, Baria. With that, we wish you a good rest of your day or evening, depending on where you are joining us from. And thank you, and keep, please, if you get an opportunity, do fill out the feedback form. It helps us to tailor these sessions and improve them to ensure that we're meeting the needs of the region. So we really appreciate if you take a few minutes just to let us know what's good and what can be improved on the sessions. Thank you very much. Bye, everyone.